Thank you. I should start out by thanking you all for staying on till this last panel of the day. I'm glad to see there are still people in the room. Have you seen the weather outside? It's amazing. But instead you chose to stay in here inside to hear about GDPR and TCF. I love the GDPR myself. Anyone still in here with a law degree? I would have loved to be a lawyer in this GDPR era. Just pick any company and ask them, are you GDPR compliant? Are you sure? You have a website? You have a newsletter? You do online advertising? Ha! There's no way you're GDPR compliant. It's like Christmas every day. But, well, now we have the TCF, which will hopefully solve some of the advertising issues. I'm sure we will get back to that. The GDPR came into effect a little more than a year ago, so how has it performed up until now? The European Data Protection Board issued a status report after 9 months stating that the national DPAs have reported 206,000 cases related to GDPR so far. 95,000 of them were complaints. That's roughly one complaint per 5,400 EU citizen. By now, we have 7 national DPAs who are looking into behavioral advertising in Poland, Ireland, Spain, Belgium, Netherlands, Luxembourg, and in the UK. So, when can you truly be sure to be GDPR compliant? And not to mention any of the other big elephants in the room, like the e-privacy looming around, the internet tracking prevention from all the big browsers out there. Sometimes it truly feels like an unsafe business environment. To make us all feel better again, we have put together a great panel to cheer us up.
I didn't know that was I didn't know that was our job, is all I was going to say. But hopefully we will do that.
I hope you will. So before we dip into the TCF, I would like to spend a few minutes sort of taking a look at the GDPR from a higher perspective. Perhaps we should start with Alice, ladies first. Perhaps you could tell us a bit, so speaking from the buy side, how has the GDPR affected the industry during the last 12 months in your perspective?
Yeah, good question. I was thinking back to how we all felt as GDPR was approaching, and I found I was getting a little bit, my heart racing, thinking about how we all felt a little over a year ago. There was so much uncertainty as that date approached. Would European inventory go dark overnight? Would data still be available? Those worst case scenarios didn't come to pass, but what I've seen on the buy side is that uncertainty that existed before GDPR still does exist today. Less so, but there's clearly still some to be learned about how regulators think about the industry. And so overall, I've just found that it has forced a lot of really hard conversations and decisions internally. Advertisers have had to decide, well, first of all, to better understand the data that they process, what those data flows are, how to look at that legally. And then sitting in the middle as a vendor, I think we, like advertisers, all of us have had to have really tough conversations with each other because we may have one view and other parties have a different view. There's been a ton more work and a ton of difficult conversations to come to a workable industry. I don't mean to make that sound all bad, though. I think overall GDPR has had a really strongly positive effect. I think that, like we heard earlier, consumer empowerment is critical. And I think GDPR really gave privacy experts, executives, the leverage that they needed to actually effectuate those changes. So I'm a big fan of GDPR. I sometimes get odd looks when I say that, but I think it's been a really powerful, positive step for advertisers and other stakeholders.
So buy side, a big fan of GDPR and a lot of internal discussions and reflections going on. Stefan, from a publisher's perspective, is that an image you can recall?
So yeah, this is this 1 year after question we get all the time. So contrast to you, so we did not expect too many changes since, strictly legally speaking, the wording of the law has not changed. So it's the same wording. So I think what has changed, really changed over the year is that the public interest in the topic as such. So we got from being under permanent scrutiny, this was always the case, to more being in the limelight. And for me, as a lawyer, being responsible for data protection law and strategy here, it's the more this permanent discussion with the stakeholders, be it clients, customers, be it the authorities, being it NGOs, being it anybody talking about GDPR, data privacy, e-privacy in the future. So it's more this from permanent scrutiny, just trying to do it right in a conversation with the authorities, to be actively challenged to prove that what we are doing is correct, is compliant under GDPR, is the right way to do it. It's balanced, it's fair, it's reasonable. So I think this is looking back during over the past year. So it's more this open dialogue rather than just applying the law, just so defending a position and permanent advocacy and teaching and explaining why what we are doing is in compliance, not just with the letter, but also with the spirit of GDPR.
Thank you. So obviously the GDPR is not an entirely European issue. Dennis, looking from a US perspective, perhaps, how would you reflect on what's going on in Europe? And perhaps more interesting, what do you see going on from the US side?
Yeah, I think GDPR and sort of captured already a couple of times in some ways was a wake-up call on a global level, right? And that's I think that's a pretty fascinating development in and of itself. When we as IAB Tech Lab started to get involved and started working with IAB Europe on the transparency and consent framework, I think we were still to some degree, correct me if I'm wrong, but I feel like we were still pulling some companies along to make it a priority. And then May 25th hit, and lo and behold, it's a priority for everyone. And so what's been interesting in the US is that I think GDPR was a global wake-up call. I think now we're seeing companies come to us and say, well, there's this thing happening in California called the California Consumer Privacy Act. And we, unlike with GDPR, we don't have to ask member companies to participate in developing a solution for CCPA for short. They're asking us, how can you help? How can you help? Because this is really important. And they're asking also, more broadly, the IAB in the US to help with federal privacy legislation to the degree that we can, or that the IAB can. Because if you can imagine, a patchwork of completely different state-by-state laws in the U.S., which is where we seem to be heading at the moment, with 17 states pursuing different legislation, and California having passed it, that gets to be a very complex environment to operate in. And I think where we are, though, is that the industry as a whole recognizes we have to do the right thing for consumers. We have to provide transparency and control. And I think we're on a good road there, but it's we owe a debt of gratitude in many ways to GDPR to push us there a little bit faster, push the engagement, and now we have to figure it out very quickly.
We are definitely on the road now, and a lot of important lessons have been learned. So is it safe for now to say that we are good with the on track on sort of figure out GDPR, or is there anything more that we can foresee in the next foreseeable future in terms of regulations, Tony, perhaps?
Well, I think one of the surprising, perhaps we should have anticipated it, but one of the most interesting aspects of the period we're in now, so that we've been in, since last May, and I think it's going to continue for a while, is that we are on this journey with the DPAs, companies, lawyers, everybody all together, trying to understand what the GDPR really means. So everybody could see at the beginning that a lot of the language, it's a big, giant omnibus regulation, a lot of the language is ambiguous. And we have to watch now how the DPAs coming together in the European Data Protection Board, which now has decision-making authority, and who's the only check on whom is really the European Court, how they what they start to lay down as markers in terms of how we should understand some of the important terms, consent, some of the conditions around consent. And Stefan is right that the structure of the law is exactly the same as in 1995. And but I think this the acuteness and the focus and the scrutiny, and I think it's interesting also to watch the DPAs almost competing with one another to lay down those markers, be the first to have an interpretation. There are a bunch of DPAs who are really interested in leading on regulating ad tech, on applying the GDPR to ad tech, partly because, as Dennis, a technical person, says about a law, it's fascinating. It's absolutely fascinating. And partly because there's actually, to the extent that there is any, that breaches are found, there's actually quite a lot of money to be gained by an authority that finds a breach, because the fines, that is one of the things that has really changed with the new regulation. So it's fascinating, and there are important opportunities for leadership by the DPAs, and we are going to need to watch very carefully and engage in a very constructive and energetic way with the DPAs to contribute to how that interpretation exercise lands.
Thank you. And Thomas, as someone who has deep insights on both the buy side and sell side of the GDPR questions, perhaps you would be the right one to sort of recap this first part about GDPR, to sort of say, what would you say would be the most important issues to focus on in regards to GDPR?
It wasn't the end of the world, as some had predicted it would be. But I think it's due to the fact that we as an industry worked together to come up with the transparency and consent framework that has solved some of the challenges that the GDPR brought. And so I think my mission next year or this year and 2020 is going to be to actually promote the transparency and consent framework, to make it work, to make it a success.
What a brilliant cue to bring us on to the TCF. Before we look more into some of the updates and the specific details, perhaps, Tony, it would be helpful with a sort of, if you could share some light on what was the background of the TCF and what exactly is it?
Yeah, so I'll take a shot at this and see if the colleagues want to back me up. So it solves a very simple problem, which is that the third parties sitting behind the website that are helping deliver advertising and personalized content and do measurement on sites don't have a direct link to the user, so they have no way of organizing with the user that they have either the user's consent to process personal data, to do that data processing, to deliver that advertising or personalize the content. And so that one needed a mechanism to make sure that those important technology partners would have the legal basis required organized on their behalf by the website, whether it's media or a different website. And so the TCF just solves the problem of providing a standardized way of obtaining, logging, and communicating information about user agreement for processing of personal data in connection with those things, digital advertising, personalizing content, and in a way that the whole ecosystem can see, the whole chain can see. So that's one rendering of what it does.
So the first version of the TCF was actually launched almost also a year ago, as I recall.
A year, yeah.
And of course, there has been some important lessons learned, and now we have seen the draft for version 2.0 being put out there for comments. But Alice, perhaps you could share some light on some of the issues and how the process has been going on, what feedback we received.
Yeah, so just in general, so you understand how the framework is managed, there's a steering group which has many subgroups working on all sorts of things, from policies to the technical aspects of it with IAB Tech Lab. There are, at last count, 120 members of the steering group. That's grown over time as people have learned about the framework and have developed an interest in it, which I think is a testament to how successful it is. Those members come from 48 companies, including 18 publishers, so really good representation across the industry. Like you mentioned, the framework launched in April of last year, and so we've had a year to sort of look at it, and like anything, version 1, hopefully hits the mark, but also it evolves. We didn't stop making cars with the Model T. We didn't stop making cell phones with the very first. So like anything, we've realized that there were improvements that could be made, which are really important. And that was based on feedback that we got from a number of different stakeholders. Publishers were one very big source as they learned more about it and thought it through more. They had a lot of very smart additions, things that could help give them more control over the vendors that they work with. Very importantly, though, we've gone out to regulators and gotten their feedback, because this is no good if the regulators don't think it's any good. And so the IAB Europe has had a number of conversations one-to-one with data protection authorities just to socialize the framework. Does it hit the mark in their mind? If not, what could we do to improve it? And so taking feedback from all of these different sources, there were a number of areas that we thought could be improved around for example, regulators had thoughts around the user experience, the clarity of what they were seeing, whether they had the ability to exercise some of their rights through the framework, that sort of thing. And so the past year has been taking that feedback, and it's a slow process when you have that many stakeholders, but really shaping that into a version 2, which went into comment period in April.
And I'm not sure, Alice, perhaps you could actually even elaborate a bit more on the policy updates.
Yeah, so there were, I would say, 3 major areas. The first one was around the processing purposes, what you can process data for and what type of data you can process. There was some thought that could be made more granular to give users more control. In all of this, we wanted to make sure it was very clear to users, what is this pop-up box that they're seeing? What does it actually allow them to do? And originally there were 5 purposes in TCF version 1. That has been expanded in version 2 to 12 purposes, which may at first sound crazy, like who's going to read through 12 purposes? I'll get to that in a moment, because that was definitely a concern. Number 2 is just making the language a lot more clear. It was sort of, concise in the first version, which meant there was an opportunity for us to go back, look at that language, and think about how would it make most sense to users, and also how would it make most sense to other players in the industry, because we all know we've got crazy terminology, right? We understand things in a different way. So version 2 has a user-friendly version and a vendor version. And then third, the concept of stacks was introduced, which is just to say, again, going back, we've got 12 purposes. How do we present that clearly? So stacks are a visual way of presenting the purposes that makes them a bit clearer and easier to digest. Doesn't take away any of the control from the user. They can still go make super granular choices, but they have a little bit clearer experience with the framework. So purposes and features were a big first change. The second was providing improvements to the transmission of and presentation of information around the legal basis of legitimate interest. So it's the transparency and consent framework, and that was the original sort of intention that evolved over time to also include legitimate interest. Version 2 adds some greater clarity around the policies and technology used to actually capture that and communicate it. Importantly, again, putting the consumer first, giving them really clear control in the little pop-up boxes over legitimate interest, and also allowing them to express their right to opt out in the through the framework. And then the last one, just additional publisher controls that would make sense. Publishers wanted to be able to say, I want to work with this vendor for this purpose, but not for that purpose. They couldn't do that in version 1. They can now in version 2. They can also specify things like which legal basis they want vendors to operate on. So overall, greater clarity, control for users and publishers, with the net result, which I think is really important, greater assurance for everyone down the line that it was clear, it made sense, the notice was presented, the user had a choice. And I think importantly, given that assurance is now really strong, that really paves the way for even greater adoption going forward.
Good, thank you. I'd like to pick up on the last issue you mentioned, more publisher control, and speaking as someone who has definitely followed the process around getting to the version 2.0, I can say that a big part of the objective have been to provide publishers with more control. So, Stefan, perhaps from a publisher side, have you gained more control?
Yes, as publishers, we have gained more control, and maybe start just with the reason. So it's not just for the sake of gaining control, having control, controlling. It's more, again, legally speaking. So what we will be facing as publishers, of course, on the one hand, we are the last mile, so the direct contact to the users. So those who are in the unique position to collect consent or to offer the opportunity for the user to object. So the opt-out or the opt-in, consent or opt-out. So this is with the publisher as the face to the customer, but the downside of this role is, of course, liability. So we'll be facing, or we expect in short term, decision by the European Court of Justice, which might make publishers and those processing data tracking on their websites joint controllers, so joint liability for both, and therefore, of course, it's absolutely mandatory for publishers to be in control of any data processing on their website. So it's a simple legal necessity for them. So if you're liable, of course, you have to have control, and this is exactly what IAB TCF 2.0 will be taking into account in three different ways, 3.5. First one, of course, a selection of those vendors. So publishers, of course, have to make sure that only those vendors they trust are permitted to track on or to process data, collect data on their websites. So this is first control. Second control is about the purposes. Selection of purposes, which purposes are allowed, which stacks will be presented to the user for consent or opt-out. And this half one is, since purposes are more granular, of course, gives you bigger controls. So you can simply cut certain processes, just maybe tracking and recognition of the user, and then no profiling also if you do not want to allow it, since it's too dangerous for you from a risk management perspective. And the last one, of course, is whether you go for consent, so stronger requirement, or whether you think this specific purpose as applied by the vendor is still covered by legitimate interest. So this is the third way publishers regain control, the control they deserve and need from a legal point of view.
Okay, so Thomas, this increased level of publisher control, do you see that as a threat or something with interest?
Definitely not.
The feasibility to sort of serve all sides of the market?
No, it's not a threat. I think it's a good thing. It's bringing, again, more transparency, but and you need to provide that transparency to publishers and then the controls that come with it. But I think it's actually creating an opportunity. So an opportunity for buy-side players to engage more with publishers, to explain what they're doing with the data, to be again like a bit more transparent. I mean, we've been hearing this all day. There needs to have more conversations need to happen between publishers and advertisers, agencies. That's just another example, and it's a good one.
I'd just add there that I think it's an intended consequence in many ways of the transparency and consent framework is not just transparency for consumers, it's transparency throughout the supply chain and understanding, who are all of the different vendors and partners and non-partners and unknowns and who are maybe engaged in in delivering ads when you're a publisher. You previously didn't know all of those parties necessarily, and this really, I think, helps to shine a light on who you work with intentionally and who you may not have realized you should be talking to, who was actually providing, a vendor that maybe was providing a lot of value, but you don't find out about in a way until you have to obtain consent on their behalf, right? It's a pretty interesting relationship builder, to your point.
And you mentioned all the many vendors and even more publishers and websites already using the framework. That makes me want to ask, has there been any technical issues in regards of handling all this vast amount of signals going on between an ever-changing dynamic number of stakeholders?
Yeah, I mean, I think the framework has functioned pretty well. I think, stepping back for a moment, it's probably useful to understand that the framework is not a piece of software. It's literally a technical framework with a policy framework that guides all of the vendors, publishers, buyers, sellers, right, in how to deploy, how to communicate with each other. And then very significantly calls out the function of one particular role of the consent management provider, CMP, that actually does develop software, right, to manage the engagement with the consumer on your behalf and manage the propagation of consent and other signals now with 2.0 on your behalf. So it's that's what the framework is in fairly succinct terms, I think. The CMPs, there are over 100 of them. There are definitely those who've risen to become leaders as CMPs, and I think they've functioned generally pretty well. But there are a lot of them, and so it's an interesting exercise to make sure that the framework is actually deployed correctly, and that the IAB Europe has developed a CMP validator tool and service, basically, to ensure that CMPs are effectively deploying the framework. We've added, with 2.0, this is about as boring as it gets, but we've added something called a checksum, right, in the string that actually, it's a string of bits that actually is all about the publisher's selections and which vendors they work with and whether it's consent or legitimate interest. There's a very long string of digits. And it turns out that sometimes that string may not be passed correctly. And so having a checksum allows you to determine, did I actually get the whole string as it and got it accurately. So that's something we've added to make sure that everything is being passed correctly. So I think it's checks like that are useful, but generally speaking, I think technically the framework has functioned as well as we could have hoped.
I'm glad to hear it. And having arrived at checksums and bits, perhaps now would be a good time to perhaps take a step back, because besides being legal and technical experts, we are also all consumers and ordinary family people ourselves, and I bet you get as many questions as I do all the time about GDPR issues and cookies and advertising and surveillance and all sorts of stuff. So speaking as a consumer, as honestly as you can, would you say that the framework actually provides some true gains to the consumers in terms of insights and empowerment and control? This is really an open question, and anyone who feels...
Yeah. Maybe I'll jump in. Thank you. I think what it provides us with, really, and what all privacy regulation and law that's either in place or forthcoming provides us with, I think, is an opportunity to engage the consumer. And it's been this historic problem in digital advertising that consumers have not opted in to manage their interests, for example, which you've been able to do on Google and Facebook and Yahoo way back when, right? All kinds of different publishers have offered various tools for you to see what they think they know about you and manage it to a degree. And in the U.S. we've had ad choices for a long time that allowed you to opt in and opt out a bit, but people don't engage with that level of detail in large numbers. At least historically. But now it's a very prominent notice, and it will be in California too, and maybe the US, right? And that presents us with an opportunity, right, to engage the consumer. And I think the rest is on all of us collectively to make use of that opportunity, to use it as an educational opportunity to help a consumer understand the value exchange that hopefully is taking place, between consumer and publisher or service provider. If there isn't sufficient value there, then consumers will opt out, right? Or if they don't understand what we're asking, they will opt out, and that's obviously not a good outcome. So I think there's an opportunity, but it's time will tell how well that works, and we've seen some of it with GDPR, and results are initially encouraging, I would say.
I think I might jump into and support what something Alice said. I find myself feeling more and more warmly toward the GDPR as the years go by, and I do think we have big opportunity in front of us right now to make it work, to make the transparency and control paradigm work, and we need to not blow it. And the e-privacy discussion is sort of, I don't want to get into the shop talk and get too arcane, but it's like slowly, while nobody's looking, potentially narrowing the notion of consent that's laid down in the GDPR. It's over here, it's lex specialis, and it's, you really have to be a technical expert to realize what's going on. But the incidental impact on the GDPR could be very bad. So while the regulators just ruminate and while the e-privacy regulation discussions drag on, we need to bust a gut and make this framework deliver a legal basis for the processing of personal data in connection with digital advertising and personalization of content, at the e-privacy access. And this is our chance to show that programmatic advertising can be done legally in a perfectly compliant and respectful way. And I think we have really 18 months to make it work. And it's an exciting opportunity, but real challenge, I think.
I think it's very important, and it has to happen now. So it's very clear. You mentioned, you called it making Europe a no tracking zone. So it's very simple. We have to be absolutely clear about this. So the European Commission and also the data protection authorities, they have a clear vision, absolutely clear. They want a no tracking zone. So any form of tracking, be it based on consent, be it based on legitimate interest, is bad in their view. So you can see it from the first draft of the privacy regulation, clear. You can see all the guidelines from the European Data Protection Board and the national data protection authorities and so on. So they have a clear mission and a clear statement. So they're crystal clear about their view. And now it's up to the opportunity. So how can we find some sort of compromise? First of all, with regard to legitimate interest, I think there's clearly a certain consent fatigue. So people or users simply clicking on and simply accepting or giving consent without even reading the text. I see myself, so I'm doing this all the time. So this is maybe the wrong direction. So this is a strong argument for legitimate interest to balance different interests and to come to a solution which benefits all the user, getting content at a lower price or for free. On the other hand, those who provide this content being able to finance their investments and to invest in good content and providing it to the user. So on the one hand, and consent on the other hand, since you ask of you as consumers, yes, there's a clear tendency to go to clear direction for consent. This means walled gardens. So consent, if you want to prove consent, strictly, again, for if you're challenged in court and some whatever NGO or consumer would simply claim that he or she did not give consent. So in order to prove consent, to be on the safe side, you would have to identify the user to say, okay, if Jane Doe, John Doe complains, to prove in court or in front of, for an authority that Jane or John Doe gave their consent, you have to know them, identify them, and it's somewhat contradictory to the idea of data protection that in order to prove consent, you have to identify this person, not from a data protection point of view, but more from a procedural point of view, administrative law or civil court, for civil courts, in order to provide consent. So it's both detrimental. So balance of the TCF, if it gets so this balance, on the one hand, this vision of a no tracking zone in Europe, on the other hand, the TCF, which provides clarity and self-determination to the user in order, if the user is interested, so no consent fatigue on the one hand, the more we accept a legitimate interest. I think this is exactly getting this balance and promoting it as we do all the time.
Yes, I think you're right. There are definitely a lot of legal challenges out there. But it also reminds me, as some of the other speakers up here has already mentioned, we have another challenge for the TCF lurking out there in regards of internet tracking prevention from all the big browsers. And again, an open question, perhaps starting with you, Tony. Do you think that ITP will suddenly prove the TCF obsolete? And perhaps for the other few, do you still think that we will be able to sort of deliver targeted advertising looking 12 months ahead?
So I would obviously hope not. And maybe the most relevant observation I personally could make is that, of course, the TCF is completely agnostic with respect to the technical implementation. So it doesn't have to be cookie storage. There could be, there are other ways, just a protocol that describes how the information has to be captured and transmitted. And with that, I would hand off to Dennis.
She's right. No, I mean that's certainly true. I think there are adopters of TCF who today use cookies, right, to transmit the signal, and to the extent that browsers block those cookies being made available across sites, that's a problem, obviously. But yeah, I think we need to look at alternative models there. That's one path of how do we make sure TCF continues to work. People talk about blockchain, for example, which we could have a whole day on blockchain, but there are other mechanisms. There are other browser-based storage approaches that could be pursued over time. But I think the even bigger question is to what degree does the blocking of tracking and cross-site cookies just change the nature of the 12 purposes, for example. How many of the 12 purposes can actually be achieved by most parties in the ecosystem without cross-site cookies? And that's a key question. I think we've seen Apple with Safari laying down a pretty clear path of blocking pretty much everything. We've not seen the same with Chrome, right? I think that's very much an open story right now. They've made some announcements, but it's not. This is part of Google, and love or hate Google, right? They have a very large advertising business that I think they're not. Not likely to torpedo with Chrome, but they have a delicate line to walk. And for that matter, Microsoft has a pretty big advertising business and also still has the Edge browser, which is number 3 globally. That's I think we stand to be able to work through some of the issues with them as well and figure out what can be sustained here from a sort of cross-site cookie or cookie alternative perspective, and that means that there's some future. But it's not like it's obvious right now, and it's not an easy path forward. It's responsibility on all of our parts and a lot of ongoing conversation to make it happen.
Any more short remarks? Time is running out, but I will allow you to make any short comments
I just
before I conclude?
say one small thing. So one of the colleagues mentioned that we've done had some very interesting discussions with DPAs, with Alice, I guess, in the course of last year. This is our annual conference. Our national IABs are here, and those meetings with the DPAs have happened in the main, because of and facilitated by and with the participation of the national IABs, and that's a really important tandem. That will help our future evangelizing, and so I thought it's worth calling that out. As I'm sitting here.
Okay, so thankfully the TCF will hopefully be very sustainable and also prove very useful in the months and years ahead. I think it's safe to say that the GDPR has definitely been an interesting journey so far. It's had a huge impact on our industry. And it's definitely important to focus on getting the right solutions in place out there. The framework obviously being the best industry proposal for this right now. Technical tracking preventions will prove a challenge, but nevertheless, there will still be a role for the framework. Are there any more important points I should draw up at this point, or should I just thank you all for staying on for this last panel once again, and thank you very much for the panelists.
Thank you.